Good afternoon. I'm Ron Tempest. I'm a partner in chair of the environmental practice group here at Vinson Elkins. Thank you for joining us for today's session and the ongoing and upcoming Trump transition. This is part of a continuing series from Vinson and Elkins that will consist of both webinars such as this and published content. In fact, a couple of events have already happened connected to the IRA and the energy regulatory arena. And you'll be seeing more from us. You can see, for those online, you can see we'll have a web page up on at V&E that is shown here that you can navigate to using the QR code or the old-fashioned way of Googling our website and then going from there. As for today, first a bit about who you'll be hearing from and our associated perspectives. The three of us who will be speaking today have all been involved in presidential transitions. As I mentioned, I'm Ron Tempest. I'm a partner in our Washington, D.C. office, the chair of our environmental practice group. For example, in my case, I was both an outgoing transitioner during the Bush 43 administration when I was the Assistant Attorney General for the Environment Division at the Justice Department. And then I was the deputy team lead for the Justice Department transition planning process you'll hear about for the first Trump administration. Zach Terwilliger here to my left, your right, was part of what we will call, or you'll hear about the day one landing team at the Justice Department during the Trump administration. Later went on to a Senate confirmed position as the United States Attorney for the Eastern District of Virginia. And then joining us separately on screen is Jeremy Marwell. Jeremy was most relevantly here was part of the Office of Legal Counsel in the Justice Department. That is an office that often helps prepare the things like executive orders that the president will sign and issue early on in the administration. He was in that role through several transitions, so has seen it from all directions. Jeremy is the chair of our appellate practice. We understand this is a critical and difficult time for companies. You're facing regulatory and policy uncertainty. May feel a little bit like you've been through a dryer or something over the last few years. Just quick trivia question. It may feel unprecedented. So as of January, we'll have basically had 4 presidents in an 8-year period. President Obama, President Trump, President Biden, President Trump again. Anybody want to hazard, and those were alternating parties. Anybody want to hazard a guess as to the last time the country has been through that experience? And if I had been smarter, I would have had a slide or a poll question for us on this, but quick guesses? So the short answer is that great generation of bearded presidents, the famous presidents Arthur, Cleveland, Harrison, and Cleveland. A time considerably before the modern administrative state. So if it feels like this is something you haven't been through before, you are right. Just moving forward here a little bit. Here's today's agenda. I would characterize it in a couple of ways. One way of thinking about this is we want to help you understand the levers of power. What is it that a new administration can do quickly? What takes longer? Where do the courts play a role? Where does the administration have more room to act unilaterally? And on top of all this, where might Congress fit into the mix? Another way of thinking about it is to talk to you a little bit about how to read the newspapers in a smart way. There will be a lot of headlines at a lot of different points about the administration instituting X change or Y change. Sometimes you'll be maybe shocked to hear we don't always think that the news coverage gets it quite right or with the level of sophistication that you need to be kind of running your affairs. And so we're going to walk you through some of the things that you will hear about because they happen with every change in administration and maybe come to a little better way to understand and think about those things. And another third way to think about it is chronologically. We'll walk you through kind of the ordering of events as things tend to play out, what happens quickly, what happens a little slower. So with that, I'm going to turn it over to Zach to take over. Sort of capturing the spirit of perhaps where we are right now as one administration is leaving and a new administration is coming in, and maybe trying to redirect the traffic.
Thanks very much, Ron. Next slide, please. Okay, we're going to talk about the period we're in right now. Again, my name is Zach Terwilliger. I've spent my whole life inside the Beltway, so I'm affectionately known as a swamp creature. I know DC inside and out, and it's where I've grown up, and have the pleasure of being Ron's partner in DC along with Jeremy. So welcome again to all of you in this room and the almost 300 participants we have online. So where are we now? We're in that stage where we move from campaign rhetoric to actually governance. And you're seeing that take place, and you're watching that happen in real time. And all of you have seen the slew of announcements about who at least the president would like to fill certain roles. So that's the process we're in. And the way I like to describe that is separating the wheat from chaff. There are things that are campaign promises, campaign rhetoric, that are then very, very difficult to actually accomplish in Washington. I will say, as we saw in the last Trump term, maybe more so than any president, he is committed to delivering those campaign promises and does not let sort of the typical bureaucracy and morass slow him down. But just some things, for example, some of you may be familiar with Project 2025, which was a document that was put together by the Heritage Foundation, and you heard that anyone affiliated with that wasn't going to have a role in the administration. We've seen people already who are affiliated with Project 2025 being named to some positions we're going to talk about. Tom Homan, who is an outspoken immigration reform proponent in the last administration, then during the Biden presidency, and now, as the border czar, has already started talking about the way the military may be used in immigration. Very different statements than were being made on the campaign trail. And we're starting to see the transition take shape. And as the slide says, personnel will matter. It's ultimately going to be the individuals who are filling these roles that are driving the agenda. One of the things that typically happens in a transition, and Ron specifically took part in this and actually was part of the agency review team in the last Trump administration and was reviewing the Department of Justice where I ultimately landed, is this agency review process. And what that really means is you're going in and trying to find out, okay, what cases are pending? What personnel is where? You're not getting confidential information, but as the slide says, more of a bed check on, where are we in terms of full-time equivalent employees? Issues like that, so that when the Attorney General or the Deputy Attorney General or the Secretary gets there, they know what they've inherited, and it basically is a briefing book that gets the landing team up to speed. Next slide, please. Okay, one of the things that's happening right now are these major selections, so leadership selections. And I think the easiest way to divvy those two up are cabinet level positions and then those that don't require presidential appointment and Senate confirmation. So we use the term PAS, presidentially appointed, Senate confirmed. And so some of these positions, a lot of the ones that you've heard, and there's going to be a chart here in a minute, the president talk about, are those presidentially appointed Senate confirmed positions. Those obviously require the confirmation of the Senate. So that's the check and balance there. But there are many positions below that level that are what we call Schedule C political appointees, where you are a counselor to the Attorney General, a counselor to the Deputy Attorney General. And on January 20th, you will take your position as a political appointee in the administration. I think we're all familiar with the oath. Sorry, back one. Yep.
Sorry.
We're all familiar with the oath being taken there. That's former Deputy Attorney General Rod Rosenstein and former Associate Attorney General Rachel Brand, and that's their confirmation hearing. One of the things we also saw in the last administration is when you're going from one government to the next, there are certain people that have to occupy certain roles. And I'm going to talk more about that under the Vacancy Reform Act. But one of the things you typically would see is someone from the Biden administration occupying the role of say, acting attorney general. That person occupies the role as a steward or a caretaker till their successor is confirmed. Some of you may be aware the last time that happened, that individual who's occupying that role was dismissed and a new acting attorney general was brought in. So I think our belief is, as we move forward through this process, the Trump transition is probably going to bring as many of their own people in on day one rather than rely on those holdovers. Ron mentioned this a minute ago, and we're going to talk a little more about it. Inauguration day landing teams. If you're like me and you really enjoy sort of the inside Washington knowledge, what happens on Inauguration Day is actually pretty special. It is where individuals fan out across government, physically go to the office buildings, and then wait for the inauguration to actually happen and take over government. And so that's what we mean by these landing teams. And they're generally lean teams of political appointees who have been vetted, and their job is to go in there and, quote, secure the beachhead until their principals get confirmed and come in and run the organization. Next slide, please. So I'm not going to go through all of these, and spoiler alert, because the President-elect Trump has been so prolific in his announcements, we already have 3 charts of the people that he's mentioned. If we can just go back one, Ron. One of the things I did want to point out is, if you look here under the Department of Justice, you can see Attorney General, Deputy Attorney General. I mentioned a moment ago, those are presidentially appointed, Senate confirmed. The PAS, those are both PAS roles. The Principal Associate Deputy Attorney General is not. So the individual who's been named for that, Emil Bove, that is somebody who, assuming he winds up in that role, would be there on day one and does not have to be Senate confirmed, and would be one of those high-ranking political appointees who lands. Also of note, and kind of near and dear to my heart, the U.S. attorney community. For those unfamiliar, U.S. attorneys, there's 93 across the country. They're the chief federal prosecutor for a particular district. Those are presidentially appointed, Senate confirmed, and typically that process goes through the Senate, where the senators come up with recommendations. Those go to the White House. There's this accord that happens, and then ultimately a selection is made. As some of you may have heard, the Southern District of New York, which is often considered one of the most preeminent offices in the country, the president, very much breaking with tradition, has already said he intends to nominate Jay Clayton for that position. Next slide, please. So you can just see here, we broke them down. I'm sure many of you are familiar with Marco Rubio, the senator from Florida, Elise Stefanik, who played a prominent role in the campus protest hearings, and then you can see some of the others listed there. And I just note that down there at the bottom, Border Czar and Department of Government Efficiency, those are 2 newer positions that are coming in on the Trump campaign. Next slide, please. And then finally, we see those folks who are really responsible for running things in the White House. And many of you are probably familiar with some of the names who've appeared on these lists before in terms of chiefs of staff. And so Susie Wiles has been named that individual. She was the Trump campaign manager and someone the president-elect trusts implicitly. And these are the individuals who will be helping to run the White House. Next slide, please. Okay. Day one of the new administration. So it's January 20th. It always typically in DC happens to be a freezing cold day for the inauguration. And what happens? We fan out across government. The president is there at the Capitol taking the oath of office. And then as soon as the oath is taken, government is stood up. Next slide, please. So hour one. What literally happens in the hour after the president is inaugurated? President's sworn in, then what? As I mentioned before, landing teams fan out across the government. You start to implement change, whether it be personnel, whether it be executive orders, which we're going to talk about more in a minute, legal positions, and a total stop is put on certain positions that were just active moments ago. This is the actual peaceful transfer of power without a shot being fired that so many civics and government teachers talk about. One thing, again, just some insider Washington knowledge. Imagine having the most secure event possible. You're trying to get people in these buildings all across the country who have no credentials because they are not yet employees, and you're trying to stand up government on this day when all heck is breaking loose across DC. It is something to behold. Next slide, please. Okay, it wouldn't be a true Washington presentation without some inside baseball and some actual pictures. So I know we don't have any issues regarding copyright because I took all of these pictures myself when I was on the landing team. So let me just briefly go through those so we can stay on time and turn this over. So on the left, that is literally the DOJ landing team watching the president get inaugurated from our transition space, which is a dumpy conference room at Main Justice Headquarters. Every one of those people went and fanned out across government, and the individual who you can see seated next to the flag ended up having acting in Ron's old job as the Assistant Attorney General from the Environmental Division. And so that's where we all gathered, and at 12:15 or 12:17, we all fanned out. Down below in the lower right, you can see what I mean by DC literally being locked down, National Guard troops, making sure the city is secure, fences everywhere, very hard to get around. On the lower left, I'm sure many of you are familiar with the Roosevelt Room at the White House. Depending on whether there's a Republican or a Democrat in power, they change the picture. When it's a Republican, it's Teddy Roosevelt, and when it is a Democrat, it is Frederick Delano Roosevelt. So that's the Roosevelt Room. And then up above, that is the acting attorney general being sworn in at about 11:50 p.m. after after the prior acting attorney general was dismissed just hours ago. And for all of you who think this is filled with a lot of pomp and circumstance, as you can see, it took place in an office. There's that org chart in the background. There's a gym bag on the floor, and there's a Bible, and we got it done. So that's how we get scrappy in Washington. Next slide, please. Let's skip to the next one, Ron. Okay, personnel, you've heard me talk about this a little bit. 4,000 politically appointed positions across the executive branch. We talk about advice and consent of the Senate that require approval. Two things I'll hit really quick. One is recess appointments. You've heard a lot of talk about that. Is this president going to utilize recess appointments? For that to happen, Congress actually has to go in recess. And most recently, the way they avoid doing that is having the senators or representatives from Virginia or Maryland come over and hold pro forma sessions, so they never go into recess. In order for the president to make a recess appointment, it has to be a period longer than 10 days. For that to happen, both chambers have to agree. I just read something about the nuclear option. You're going to hear more and more about this in the weeks to come. The nuclear option, which is in the Constitution, which has never been utilized before, is in the case of a disagreement about whether to go into recess between the House and the Senate, the president can actually adjourn Congress. Stay tuned. You're going to hear more about that in the weeks to come by the talking heads. Next slide. Okay, last one for me, the Vacancies Reform Act. I think the main takeaway that you should have on this slide is generally, if it's a presidential appointment, Senate confirmed position, there are only certain people who can occupy that position, and those who are eligible are listed there. What's interesting under the for how long part, you basically get these over and over 210-day periods. And so we saw this in the last administration and the prior Trump administration, where you have people who are in these acting roles under the Vacancy Reform Act for 210-day periods, and those periods reset when there's a nominee.
Thanks, guys. We'll turn now to another very high-profile day one action, and that's the things that the president can do all by himself with his pen, executive orders, proclamations, memoranda, and the like. Some of these are probably already in motion behind the scenes, I imagine, so that they can be rolled out on the first day. Now, a key thing to remember about this day one type action is that generally the president is not going to be able to change the substantive law by doing something unilaterally, whether you call it an executive order or the like. The president can signal where policy is going. He can give priorities. He can direct subordinates to consider taking, or perhaps even direct them to take certain actions. But generally, the president is not going to be changing policy, changing a statute, amending even a notice and comment regulation right away. Now, President Biden issued a number of day one orders, some of which wiped off the books actions by his predecessor, by President Trump. I would not be surprised to see the pendulum shift back, given the particular person who's coming back into office, probably rescinding issuances by President Biden and perhaps restoring policies or orders that are similar to or perhaps exactly the same as actions President Trump had taken in his first administration. To give you a sense, I mean, the traffic jam slide comes back here too. There are resource constraints on how much can be done in one day, afternoon. President Biden had something like 17 issuances on Inauguration Day and another 10 the day after. So most of those things, as I said, had to have been prepared and in motion before Inauguration Day in order to be rolled out that quickly. This is also a trend that we're seeing with increased emphasis on immediate action. If you look at the period from Inauguration Day to April 30th, President Biden had more than 50 kind of unilateral actions. President Trump in that same period in his first term, 39, President Obama, 34, President George W. Bush, 13. So we see an increasing emphasis on getting in and get going fast. There are some areas, notwithstanding what I said earlier, where the president does have legal authority in his own right to really do things that have legal or practical implications, but they're going to be specific. One is on the slide, leaving or rejoining the Paris Climate Agreement. Another example, something President Biden did on his first day, was to effectively halt construction of the border wall, but he did that by terminating the national emergency that President Trump had created by declaration or had declared in a declaration that made the funding available. So these are going to be specific to a particular context or a particular area of law. Next slide, please. So of course, President Trump is not only going to be rolling back President Biden's initiatives, he's going to be affirmatively advancing his own priorities. You can see here on the slide some of the examples from the first Trump administration: expediting reviews for infrastructure, energy, and other important infrastructure projects. Probably we'll see border security, immigration, ethics, and sort of general rulemaking regulatory initiatives. One other thing to note: can executive orders and these memoranda be challenged in court? So will they be effective or will they immediately get tied up in litigation? The answer is, unfortunately, it depends. Most executive orders explicitly say that they're sort of internal to the executive branch. They don't create rights that can be enforced in court by individuals or anybody else. But of course, some of these kinds of actions do implicate individual rights or others. Think about the litigation related to President Trump's travel ban, very famously, was tied up in litigation in the first administration. So next slide, please. We'll turn to another important day one and maybe even minute one activity, and that's the regulatory review memorandum. Good thing to talk about if you want people to walk away from you at cocktail parties, but it actually matters. So this is something we've seen consistently across the past, I think, 4 or 5 administrations. Right after inauguration occurs, the chief of staff will issue a memorandum to all federal departments and agencies. It will be implemented through the Office of Management Budget, doing 2 essential things. One is a standstill. Anything that was in motion under President Biden's administration will be stopped and paused, and an effort to claw back things that were so-called midnight regulations or other initiatives that had gotten maybe almost across the finish line, but not quite across the finish line. This is generally an effort by the new administration to just pause everything so that the new leadership can get their hands around what's happening and make informed decisions about what should go forward and what should be pulled back. Next slide, please. So the pause is fairly straightforward. It's a direction from the president to all the subordinates that nothing new goes out, nothing new gets finalized, unless it's approved by someone who was appointed afternoon on Inauguration Day. In other words, someone in the new administration. The clawback is a little more complicated, and we've seen litigation impose constraints on what the administration can do, what a new administration can do. But the idea is that there are statutes that govern the finalization of agency action: the Federal Register Act, the Administrative Procedure Act. And if a rule has not progressed to a particular point, courts have generally upheld the new administration's ability to pull it back, prevent it from taking effect without having to go through additional administrative procedures. But and just in the Biden administration, we saw the law evolve on this point. That line has moved, made it a little more challenging. The line has moved even in the last few years, reducing the ability of a new administration to claw back without following process. And again, a fairly inside baseball sort of thing, but the line, as I understand it, is currently if an agency has finalized a rule and sent it to the Federal Register to be published, but the rule has not yet been made available on the Federal Register website for public inspection, that rule can be pulled back essentially instantaneously, unilaterally, without further procedure. But if it has been set out for public inspection, or if it's been published in the Federal Register, then the agency is sort of stuck with it until they follow the procedures to pull it back. Next slide, please. And we'll see that this matters because those procedures take a little time to work through. The final bucket of rules that folks may be following, and I should say this is important because I know many in the audience are watching for the Biden administration to finalize regulations that have been underway for many months or years. The final bucket is regulations that have been published and final, but are not yet in effect. This bucket of regulations can in some ways be even more urgent for a new administration to try to create more time, because these are rules that might be within weeks or a month or months of taking effect. Again, we've seen evolution in the case law even in the past administration, but the basic rule here is that it's risky for agencies to try to defer those effective dates without allowing administrative process on the decision whether to defer. And sometimes if you short circuit the process, you run the risk of the rule taking effect, which can make it harder for the agency to roll it back. So we'll see, I would expect to see action and potentially litigation in each of these buckets. But this was a whistle-stop tour of sort of day one, and I'll turn it back to Ron. I think we have our first CLE polling question.
You should see a polling question in front of you. It'll stay open for about a minute or so. We're going to keep moving on right now while people register their votes. If we end up with a little time at the end and we think we've got any interesting results, we'll let you know how the voting went. In the meantime, pushing on a little bit, so then we're now into the process of changing course. The agencies have their regulatory review memorandum and direction. The agency has begun to reconsider policies or regulations. We've identified some that we think are, potential high-profile regulations or actions that might be ripe for reconsideration. We sort of focused on things a little bit environmental, a little bit in the energy space, just as the nature of the audience. But you could have these same kind of things happening with respect to tax or labor or any of the many areas in which from which regulations come from cabinet agencies. Moving on a little bit, we get on to the next couple months thereafter, and trying to remind myself which of us is taking this one on. Am I still going, or Jeremy, or are we back to you? I think I'm still going. Okay, yeah, sure. Just nod and kick it back to me. So, one area that is less subject to formal process. You're not actually changing a rule. You're just deciding what kind of cases to investigate, where to put your enforcement resources, is one of those areas that's more amenable to immediate action, because there's no law that says, what kind of matters DOJ has to give priority to within a U.S. Attorney's office. Should they be focused on immigration or white collar or violent crime? And so some of these things can begin to move pretty quickly, although some of that is also a function of just what's in the pipeline. Cases that have been investigated, that have gotten kind of mature, and you can get, as a result, changes in direction in terms of settlement terms, or things that are now being allowed or disallowed. An example in the first Trump administration, in the environmental arena, there are these things called supplemental environmental projects, where sometimes are part of settlements, where company agrees to do an environmental project kind of on the side as part of getting some forbearance on the amount of penalty they will pay. Those were eliminated by policy early in the Trump administration. Another area that Zach was very involved with and familiar with is the use of corporate monitors, where sometimes as part of a criminal resolution, you agree to have a monitor who watches your affairs, studies your compliance. Those became not eliminated, but certainly disfavored. So one thing to keep an eye on with respect to this is while there will be shifts in enforcement priorities, some enforcement initiatives certainly carry over. And in some arenas, again, environmental is an example, but there's certainly others. Don't forget that the feds are not everything. Some of our environmental statutes, for example, allow citizen suits. So essentially private attorneys general, environmental groups, tribal organizations, really anybody who wants to step forward can, in theory, if they think they've got an environmental violation that they've spotted and they're injured by it, they can step forward and bring that as a private citizen. Key TAM cases, claiming false claims to the government, another area of that. And then, of course, state agencies, state attorney generals, state prosecutors of various sorts have their own independent authority that exists far and away from the federal government. So the feds aren't everything. Jeremy, I think we're now flipping back to you a little bit on the more nuts and bolts of rescinding the regs.
Yeah, in many contexts, achieving meaningful substantive change is going to require formally amending notice and comment regulations. So all the things that are in the Code of Federal Regulations. And the timing and extent of those changes are governed by law. They're governed by the Administrative Procedure Act and a huge body of case law. The key takeaway is that the APA imposes process-based requirements for rulemaking that apply to issuing a rule, to rescinding a rule, to modifying a rule, and even to deferring an effective date. These are familiar, they're black letter law, but they're worth a quick review, in part because the first Trump administration encountered some turbulence early in its, especially in early days, trying to do too much too quickly to roll back Obama administration regulations. So think of it as three basic requirements. One, you have to publish a proposed rule, put it out for public comment. There's no fixed period for this, but 30 or 60 days is typical. There are exemptions for interpretive rules, policy statements, things that are internal to the agency. If those words sound vague, it's because they are, and you can litigate what those categories mean. Once the agency has digested everything it received, it has to publish a final rule that includes a statement of why it's doing what it did and a response to comments received. And then publication of the final rule usually has to precede the rule's effective date by at least 30 days. There are exceptions here too for rules that take effect right away, including some of the words that we talked about just a minute ago, or for good cause. But the basic point is that the agency has to dot its I's and cross its T's if it wants these changes to regulation or changes to effective dates to be durable. Next slide, please. So ignoring these requirements carries litigation risk, and there are different consequences. One key precedent dates all the way back to the George W. Bush administration, where the court held that the agency had not followed the right procedures in seeking to extend the effective date of a rule that was trying to roll back some energy efficiency standards. And in addition to the procedural foot fault, which you might think, well, okay, you have to go back and you can extend the effective date again, the particular statute that was at issue there had essentially what's called an anti-backsliding provision. And so the process-based foot fault wound up constraining the agency's ability to actually give substantive relief in the context of the particular statute that was at issue. The slides give some other examples from the first Trump administration of courts rejecting efforts to roll back Obama-era rules for failure to comply with those basic notice and comment requirements we just discussed. This tends to be most important with regard to, this can be very important with regard to the midnight regulations that come out kind of in the months immediately before Inauguration Day. But the net effect is you got to follow the process or you're going to be less effective or ineffective in changing the policy. Next slide, please. So if you turn from process to substance, there are some limitations on an agency's ability to change rules, to change the law, even if it follows the right process. Of course, some of those are statute or context specific. We talked about an anti-backsliding rule earlier. There are statutes where Congress has directed an agency to take certain action or to make certain findings. All of that will be in the mix. But even if you don't have those kind of context-specific provisions, sometimes an agency can be constrained by what came before just based on the requirements of reasoned decision-making that apply across the government. So an agency is allowed to change course generally, the Supreme Court has said, but it has to acknowledge that it's doing so and it has to give reasons for why it's changing policy. Those reasons don't generally need to be better just because it's changing, but there are some contexts where there is a higher bar. If you have a rule that has reliance interests, for instance, or you have an agency that made particular fact findings, say with regard to, the environmental impact of a particular emission in a prior administration, the agency has to give good reasons that are tied to the record before it for why it's doing what it wants to do in the policy change. So one other question that I think is on some folks' minds, what about changing interpretation of the law? So we just had in June, very high profile decision from the Supreme Court, changing the framework for how courts review agency interpretations of statutes. That case, I think, is understood generally to make it harder for agencies to flip-flop, to take one reading of their statutory authority and then perhaps after a change in administration, take a different reading. So we may see more aggressive action by federal courts in reviewing agency actions that rest on a change in the law. So next slide, please. I think we have our next poll question. And as you read and digest that, I'll turn it back to Ron to talk about some other limitations on agencies' ability to change course.
Okay, so picking up a little bit on the discussion about Loper-Bright, one place where you may have more trouble is where you've got an existing scientific or factual record. So it is not purely a matter of policy, but there has been some particular finding made in the course of that. And we've shown you a couple of different examples of rules, some of which are currently in litigation and some of which are kind of mature and not so. Jeremy is going to talk a little bit about the particular challenges also that arise and the options available when something is in litigation, and does that in and of itself provide strategic opportunities. The other divide, again, these, as Jeremy alluded to, these lines are not always terribly clear, and you can argue about them, but generally courts have, I think, concluded where the rulemaking involves exercises of policymaking judgment, the agency will have more leeway. Now, again, a little bit of a question, where does Loper-Bright leave that notion of discretion to an agency, where the courts have also to some degree said courts are the people best able to understand what a statute means and allows. But within that context, it's worth noting that there are statutes that actually express things like the secretary shall, in his or her discretion, decide X, Y, or Z. So when the statute itself says there's some discretion there, even kind of plain textual readings are going to result in there being some room. So these are at least speculating a little bit on some of those that might have more room for discretion and judgment, and thus potentially a little more leeway for the new administration to make its own decisions and to try to change course. again, kind of previewing a little bit here, you've got, if it's pure legal interpretations, Loper Bright seems to suggest courts are now going to be acting more robustly. And so it's not so much a question of deference to an administration's view. And then you've got places where you have complicated things like what we've called layered rules. An example in environmental arena was that EPA can regulate pollutants that make significant contributions in what was called endangering. Well, okay, if that finding has been made about a particular pollutant, and then the rules have been adopted, say, as to a power plant or something like that, and how they have to control for those emissions, you may have a two-step process that you got to go through, because you may need to reverse the original endangerment finding, or the agency otherwise has an obligation to regulate in some fashion. One other thing, we'll talk a little bit about where Congress may play in all of this, but one place Congress potentially does play is it controls the power of the purse, and it is not unknown for Congress in its annual appropriations bills to say no money shall be spent by this agency on this rule. And that could be either as to further advancing it or implementing it. That becomes a de facto veto, congressional veto on the rule. Part of the trick there is appropriations bills last for 1 year. And so that if that ban on the use of appropriated funds isn't renewed every year as part of the appropriations process, it essentially disappears. Jeremy?
So the process of repealing or amending regulations has additional complexity when the rule in question is in court, right? It's subject to active litigation. And sometimes that overlay can make it harder, slower, less predictable for a new administration to really drive a rule or a policy towards a durable, prompt, change. I will try to talk in general about the levers that the Trump administration will have, the way that a rulemaking or a new administration can use the judicial process or survive the judicial process in trying to make change. So let's go to the next slide. So the first option, the most sort of straightforward one, is just to try to put the litigation on pause while the agency undertakes that process we talked about a few minutes ago. You want to moot out the litigation by allowing time for the agency to change the policy. There are some efficiency benefits to not litigating a rule that's going to change. But this isn't always as easy as it sounds. Sometimes the court is not going to have infinite patience. Sometimes there are other parties to litigation, for instance here, perhaps states or NGOs who intervened to help defend a Biden administration policy, who may not want to just roll over and let the litigation kind of go into abeyance. Another option, sort of a second option, is if the Biden administration has suffered an adverse decision already in court, or does between now and Inauguration Day, maybe a stay of a rule or even a merits decision setting aside a rule, obviously the new administration can either not appeal or can withdraw an appeal or just decline to appeal. In a way, this sort of lets the court do the work for you, so to speak. The judicial decision may have set aside an action that clears the way for the new administration to put its own stamp on things. But again, the presence of other parties to the litigation can complicate the approach. You may have states or NGOs who like the policy, who want to carry the torch to continue the appeal, even if the Department of Justice, the agency in question, is not going to do so. The third option, next slide, please, would be to just decline to defend the rule. This is, I won't call it a nuclear option, but it's a high stakes move. The Department of Justice, by tradition and institutional history, will defend, colorable agency actions. There may be some circumstances where a new administration is not prepared to do that. But again, if the litigation is already ongoing, it's not up necessarily to the Department of Justice. A fourth option is not just to try to put the case on hold, but to ask the court to send things back to the agency to allow the agency to revise or rescind or modify the rule. Now, the court has discretion to do that if the agency indicates that it thinks the rule is now unlawful, or that it's, after the change in administration wants to go in a different direction, you're getting bored of hearing me say it, but interveners sometimes can complicate this. One area that I think has been subject to some dispute is whether a court can vacate a rule just based on the agency saying we want to do something else, or even saying the agency, confesses error. I think the better view of the law that emerged, particularly during the last administration, was no. The court has power to set aside an agency action if it if the court determines that that action is unlawful, but it can't kind of short circuit the process by just, vacating it. That would bypass all of those administrative procedures that we just discussed. One thing to keep in mind, the last thing to keep in mind, is that the Administrative Procedure Act does authorize an agency to suspend the effective date of a rule or regulation that hasn't taken effect. That is for rules that are in litigation. It doesn't supersede the thing we talked about earlier about needing to do notice and comment to delay effective dates. And there are some statutes that constrain the agency's ability to do that in particular contexts. So we'll turn back to Ron for other things agencies can do quickly and maybe unilaterally.
And there are things outside of formal rules that you find in the Code of Federal Regulation that the agencies often call guidance or assistance to the regulated community about their view on more detailed specifics of what rules may require in a specific setting or factual context. Those are that guidance practice has been something that's gotten mixed reviews over the years. I think many times people feel like the guidance becomes de facto regulation, that you have little opportunity to run your affairs differently. On the other hand, there are moments where it's helpful to know what the agency's position is going to be rather than have to wait and get sued over it. So there are definitely pluses and minuses to agency guidance issuing. But one thing that we will be watching for is whether the new administration will institute a notice and comment process for agency guidance. That was something that was implemented as part of the first Trump administration. It, I think, was something that regulated parties valued quite highly because they at least felt like they got a chance to have some say in the way that the more formal processes for regulation allow. So, and then there is some nuance around all of this. Not all guidance is really guidance. Sometimes it truly is regulation. We won't go down that rabbit hole other than to say, if it turns out to be real regulation, then it is always subject to kind of notice and comment. So a little bit of a poll question here. You've heard a little bit about the confirmation process, about the prospect for recess appointments. You've seen how many intents to nominate. I guess there aren't formal nominations yet, but a little bit of question about people's expectations for how that process will go. I alluded to the fact that there is a place potentially for Congress to play here. And, one possibility really is, as Jeremy has artfully laid out, it is something of a daunting task, right? To roll back a regulation that is full and final, because you have the whole notice and comment process. I think it's somewhat rare these days in DC to think that Congress is your efficient solution to regulatory problems, but there is some place that Congress can play here under what's called the Congressional Review Act. And that is a statute that gives Congress the right to sort of directly intervene to veto, so to speak, a regulation that an agency has adopted. Now, there are complicated time limits within which Congress has to act. It has to do with the arcane area of legislative days, kind of counting the days that Congress is in session. None of us want to be experts in this. Big picture, what we will tell you is and actually the number of legislative days that will be used up in the balance of this Congress is still undetermined, right? Because they still have the chance to be in session and to meet through the end of the year. But there's a rough working estimate from one of the agencies that follows this that You know, going back probably into the August period is any rule that went final before that is probably going to be out of reach of the new Congress, and potentially any rule that went final after that date is going to be potentially in play. One of the things that's also unique about the Congressional Review Act is that it has some special priority within Congress. They've got preset rules on the number of hours of debate and things that limit the use of the filibuster. So it has kind of a privileged position on the congressional calendar. It was rarely used in the past, but it's been increasingly used. Part of that has to do with, for it to really have any legs, you've got to have unified government. You have to have one party in control of both houses and the presidency, because a Congressional Review Act vote is subject to presidential veto. So if you get any one of those three not aligned with rolling back a rag, they eventually, become the roadblock to Congressional Review Act. Obviously, it looks like we are going to have that kind of unilateral or that one party alignment. So there is potentially a place for Congressional Review Act activity as a way of getting at some of what we've shorthand called the midnight regulations. Quick follow-up here, question for those polling. Kind of curious about what agencies folks most care about, see most important to their day-to-day lives. Moving on real quick, a little bit of talk about the independent agencies here. We have been primarily focused here on cabinet agencies, the places where the boss is the secretary of something, Treasury, Defense, or occasionally the administrator, such as EPA or the Attorney General. Those are basically the cabinet agencies. They're a collection of these independent agencies that exist somewhat apart from the executive branch. You can see a collection of them here. They typically have 5 members. Those will not turn over instantly. Those are folks who are themselves serve particular terms. They're appointed by the president, perhaps confirmed by the Senate. The important thing to know here in terms of quick change is the one thing the president typically can affect on day one is who is the chair of that agency. That may sound like not all that important if you're, still outvoted 3-2 if you're a Republican, but in most of these agencies, being the chair is hugely consequential because it means you control the agenda. You control what gets to a vote before the full body. You immediately have some powers in directing the staff in their work. So we're not spending a lot of time on the agencies. We had an ERAG conference where there was a great deal of talk about FERC. If you're interested in that, it's available online. If you want to learn more, if there are other agencies you're interested in, please let us know. But we just want to hit that quickly. Jeremy, you want to take us home with sort of some of the other litigation issues that swirl in the background?
Sure. We can't ignore, I think, that the Trump administration is taking office at a time of really significant doctrinal change and against the backdrop of a federal judiciary that has been meaningfully affected, the composition of the judiciary, by appointments by President Trump and then by President Biden. Just last term, and many of you have heard us talk about these cases in other events, we had significant number of blockbuster decisions from the Supreme Court. I'll touch on just 2 of them. One, Loper Bright, which has been mentioned several times today. I think the case has been portrayed and understood, probably correctly so, as having a deregulatory valence. And what do I mean by that? That it is a tool that may mean that federal courts rein in expansive assertions of federal regulatory authority. In some respects, it's the next chapter in a story that includes cases like West Virginia v. EPA and the major questions doctrine. But the case cuts both ways, particularly at a time like this. If courts are exercising their own independent judgment and are not required to defer to agencies, they're not required to defer to the Trump administration to the extent it might invoke deference. And it's possible that we'll see it deployed to challenge overly narrow or overly constrained assertions or understandings of federal authority. And then just the last one before we turn to any questions that we have, the Corner Post decision, where the court, I think, as a practical matter, potentially extended the statute of limitations for challenging certain kinds of federal agency actions. Decision does not affect all kinds of agency actions. There are some statutes that have their own statutes of limitations, some contexts. But this was portrayed, I think, correctly and by the dissent in that case as potentially opening the door to challenges by industry or others to regulatory actions or rules that have been long standing, that are well past the normal 6-year period for challenges. Will we see environmental or public interest groups attempt to use this to disrupt other settled rules or frameworks that might be important to Trump administration deregulatory efforts? I'm not sure, but obviously the statute of limitations is agnostic. It applies, regardless of those principles. And so the takeaway is, at a time where courts are reconsidering the law that governs the administrative state, coming in and executing on a transition agenda may face a new or potentially more difficult challenges. So I'll turn it back to Zach and Ron if we have any questions that came in.
So we do have a couple of questions that have come in. Let's try to see what we can do here in a couple minutes remaining. We have a question about sort of generally regulatory review process. So Jeremy, listen up. This maybe is going to fall between the two of us, but there's a question about the Biden administration is doing what is called an LNG pause study. It has to do with the whether and at what pace we should allow LNG facilities to be permitted, and particularly including permitted for export activity. There was kind of a well-known effort to pause that process and to pause approvals for that. So there's a study that is potentially coming out, and there's a question about whether that would be subject to a comment period, 60-day public comment period that extends beyond January 20th. Jeremy, why don't we bounce that back and forth a little bit? I'll share a couple of reactions, and then you can correct me and say something smarter and better. One thing I would first say is basically, for sure, that study could be released for a public comment period. Something like this, I would say it's almost, in my guess is, it's almost entirely discretionary how many days the agency chooses to make available for public comment. And public comment in any of these contexts is almost always extendable at discretion. So even if a 60-day period or a period of public comment were announced that was designed to conclude before January 20th, my own view is that the new administration would have a lot of freedom and space to reopen public comment for a longer period, perhaps even to unilaterally simply decide it's withdrawing the study to the degree the study is not a formal regulatory action. But curious about your reactions on that one.
No, I think that's right, Ron. And the requirements we talked about governing publication, public comment, final rule. I mean, those apply to a defined term of things, regulations or rules. And so I would think the study in its own right wouldn't necessarily require a comment period. I
think we're about running out of time, so we'll potentially, wrap up here. Just again, thank you all for joining us. We hope it's been helpful. I think people will get survey questions and things like that. We'd appreciate any feedback. Again, going forward, this is just part of a bigger effort by Vinson Elkins to be providing guidance and information that we hope can be helpful to you all as you face the challenges of uncertainty, which is always tricky in any business. Hopefully we've given you some ways to think about these problems, and of course happy to address any questions that people will have down the road. I think one of the toughest contexts that you are going to confront is clearly there will be some effort at what we might call a regulatory rollback or regulatory reform. And one of the real challenges of so many rules is they go final, meaning they are, final, and regulations, they establish implementation deadlines that are a year or 18 months or 2 years down the road. And then you have perhaps ongoing court litigation or an announcement that that regulation is going to be proposed to be changed, and you are really stuck as to, well, what do we do? Because oftentimes these efforts take a while to be prepared for internally, to make sure you're ready once the real requirements kick in. And at the same time, you're facing the uncertainties of, or the possibilities that it may never really come to pass. Those are things that hopefully we can give you some help on how to think them through, what the real prospects are, and what some of the timelines are sometimes for these kinds of things. So with that, we thank you all again. We thank those who joined us on the line, and we will wrap it up here. Thanks very much.